Calling our last case of the morning, People versus Deweerd. Good morning, Council. This is a 20-minute grant. You have 2 minutes of free fire zone, and you may waive that. And then if you're going to save time for rebuttal, we ask that you keep track of your time.
Thank you, Your Honor. Good morning, Your Honors. May it please the Court. Mike Waldo from the State Appellate Defender Office on behalf of Ryan Deweerd. I request to respectfully reserve 5 minutes of my time for rebuttal, Your Honor, and I'll keep track of my time. One does not interfere with the administration of justice by maintaining his innocence in response to police questioning where guilt is later established. In order to score OV-19 at 10 points, more is required. Ryan Deweerd had a constitutional right to maintain his innocence, and his sentence should not be aggravated for doing so. I submit to this Court that there is nothing remarkable with what happened at the time of Mr. Deweerd's arrest and his statements. The police executed a search warrant. They seized contraband. They interviewed the occupants, the 3 occupants of the apartment. Mr. Deweerd denied knowledge, denied culpability, as would be expected for somebody in his predicament. There is nothing about this case that warrants aggravation. OV-19 is properly scored at 10 points where a defendant's conduct evinces a clear intent to interfere, which of course includes interfering with the investigation of a crime. Things like discarding evidence, things like running from the police despite an order to stop, intimidating a witness, or in Barbie, providing a false name. Denying guilt is not enough. To hold otherwise would render OV-19, or more properly characterize OV-19 as a constant, not a variable. Ryan Deweerd did not oppose the administration of justice when he maintained his innocence. Rather, he insisted upon it. I look forward to this Court's questions at any time.
What if he denied, you said he denied his awareness, I mean, at least according to the little statement in the PSI, awareness, you know, he denied using meth, was not aware of anything that was taking place in the residence, and did not know there was any kind of meth components or labs in the home. What if he denied that there was meth or meth lab components in the home? Would that be sufficient to score the offense variable?
Well, Your Honor, I think the distinction here is that the items had already been discovered. There was no point for any 3 of them to be denying anything.
All right, well, let's do a hypothetical then. So in a hypothetical case, is it a distinction? Is there a distinction? You said if he covered up evidence or, you know, presumably tried to lead the police astray in their investigation, right? Is that what you're talking about?
If he did that, Your Honor, then I think OV-19 is properly scored.
So one way to do that is you could discard evidence, right? That's one way to do that.
Certainly.
You could also deny its existence.
Prior to its discovery?
Yeah, would that be sufficient? I'm asking, would that be?
Right. I think it's different. I think it's a closer call, and I think that's actually the fact pattern of one of the unpublished cases relied upon by the prosecution in their supplemental briefing, as well as the trial court at our motion for resentencing in this case, People v. McCormick. I tend to disagree with the panel in that case, Your Honor, that did find OV-19 was properly scored at 10 points there. The defendant, I believe, was trying to deny the existence of contraband inside of his home prior to the search. The court, of course, held that OV-19 was properly scored. I think that's a very close call, and it is distinguished from Mr. Deweerd's case, as I said. But I think anytime you're aggravating a sentence based on somebody simply denying guilt, that OV-19 is...
I mean, you can have a basic denial of guilt, right? I didn't do it. That's one thing. You can then get into more specific facts that are evidentiary facts, you know, that relate to the elements of the offense, like your intent or knowledge and the existence of contraband and where it was located, whether you possessed it or were using it or distributing it and so forth, right? So I'm trying to understand where you would draw the line, which when is it properly scored? Only if you actively interfere with the police investigation, their ability to discover the facts?
Well, I think a clear intent to derail the investigation warrants scoring, as in Barbie, where the defendant simply gave a false name. But when you are tying your statements to your constitutional right to maintain your innocence, then OB-19 is improperly scored in that scenario, Your Honor. And in McCormick, I mean, to circle back, where a defendant is trying to frustrate the investigation to impede the discovery of incriminating evidence, then I think OB-19, I think it's close. And I said that I disagreed with the panel's assessment in McCormick, but I think that's the distinction. Here, certainly there was no interference because the contraband was already seized. But I
That's
also,
the biggest thing about this case. It's not necessarily as much, the short statements that he made, but it's the contraband was already discovered, so he couldn't interfere with anything.
that's part of it, Your Honor, although actual interference is not a requirement. If the defendant, by his words or his actions, evinced a clear intent to derail the investigation, I think that could result in scoring OB-19, but not where it is somebody simply maintaining his or her right to innocence, which, pared down to his essence, that's all Mr. Deweerd said. He said, I didn't use the drugs, I didn't know about them, and if I did, I would have left.
Does it matter that he made a couple of extra sentences about I wouldn't have lived there if I had known this was going on? Does that impact our analysis at all?
No, Your Honor, I think, as in Dixon, what is required is a scrutinized factual inquiry into what exactly he did here. And where Mr. Deweerd simply said, I didn't know about it, I would have left, that's not enough.
I'm having a hard time understanding the rational basis for distinguishing between impeding discovery of evidence, which is McCormick, and distancing yourself from evidence, which is what happened here. Aren't they both intended to persuade an investigator that, you're innocent?
Perhaps, Your Honor, I think the former, under McCormick, would be an intent to prevent the police from discovering the evidence of the crime. And the latter, which is what we have here, is simply a suspect.
An attempt to persuade the police that you didn't do it.
A suspect maintaining his right to innocence, Your Honor. Our system does not require and should
No,
not
I
aggravate.
get it, but he didn't have to say a word, but he did.
That's right, Your Honor. I suppose he had three choices in the face of the questions that the police asked him. He could have admitted on the spot that he was guilty and said, send me to prison. He could have said nothing, or he could have done what he did, which is to maintain his innocence and deny criminal responsibility, which was his right, Your Honor. I think that,
Well, wait, the last part was his right? His right is to remain silent. He doesn't have a right to provide untruthful information to the police, does he?
he doesn't have the right to lie and present specific facts that are lies, Your Honor. But I think a guilty person, a person who is factually guilty and knows he or she is factually guilty, has a right not to admit that, not to convict himself or herself on the spot, but to maintain his or her innocence and to require the state to prove the case.
No one's denying that the state did that, though, right? And this is after conviction, and it's just a question of scoring the guidelines.
Right, Your Honor. I'm sorry if I'm not understanding the question.
Well, I'm getting lost. You're kind of reminding me of the Animal House scene where they're going to walk out of the hearing because it's violating the United States of America. You keep adding on to it. No one says that he can't maintain his innocence or that he had a right to say nothing. But once he did, why is this meaningfully distinguishable from McCormick?
Well, I think it's a layperson's attempt to maintain his innocence and to essentially say, I'm not guilty, you can't make me admit to this. I think that's all that this is. And in McCormick, you have a defendant who, prior to the police executing the search, prior to the discovery of the contraband, is trying to thwart that search. Mr. Deweerd wasn't trying to thwart anything. The investigation had happened. The evidence was seized. He simply said, I didn't know about it.
But he had a presumption of innocence in McCormick, so can it be argued that in McCormick, he was trying to maintain his presumption of innocence?
I think it can be, Your Honor, and I think I disagree with the panel's outcome
Okay.
in McCormick.
Okay.
And I think a point that I wish to make, there's two components to scoring 10 points under OV-19. There is interference, and there is the administration of justice. Interference has been defined as to oppose, so as to hinder, hamper, or obstruct. And the administration of justice in the criminal context is the process of administering judgment on individuals. In other words, the process of determining guilt or innocence. And I don't think it's rather circular to say that one opposes the process of determining guilt or innocence by saying, I'm innocent, I'm not guilty. I submit to this court that one maintaining his or her innocence is a part of the process of administering judgment on individuals, the part of determining guilt or innocence, not in opposition to that.
It's all a matter of where we draw the line, right? Because we wouldn't be here if he simply said, I am not guilty. I am innocent, whatever.
I think that's what he said, Your Honor. In different words, but at the end of the day, there aren't magic words, especially for a layperson, as Mr. Deweerd in this situation, some magic words that one must recant to protect their constitutional rights. I think what he says is, I'm not guilty. And we
Well,
don't know,
He says
there
more
is,
than that. He could say, I didn't do it, right? That's a general disavowal of guilt. Or he could start getting into the specifics of the crime, which is sort of what he did here, right?
Had I any idea, I never would have stayed in this home.
How big of a factor is it that the evidence was already seized? I mean, apparently it was seized and he knew it was seized. Is your case rise or fall on that? In other words, let's do another hypothetical like the other case you mentioned. If it was denying the existence of the evidence and the evidence hadn't yet been seized, would that be enough to score the offense variable?
I don't think so, Your Honor, because in that scenario, one, again, is simply maintaining his or her innocence and is denying
No, it's not.
responsibility.
No, it's not. It's making a specific statement about a specific piece of evidence and denying its existence. It goes far beyond just a general, I didn't do it. A general disavowal of guilt is, I didn't do it. I'm maintaining my innocence. How
Right.
about that? We'll use your language. It's high-minded, sounds good, right? I'm maintaining my innocence. That's a general disavowal of guilt. Doesn't get into any of the particulars of the case. When you get into the specifics of the case, you clearly have gone beyond now. You're talking about specific evidence that relates to specific elements of the crime.
I think if a defendant's statements are viewed as attempting to thwart the investigation, to prevent the discovery of incriminating items that he or she may know are present, I think that would warrant a scoring of OV-19, Your Honor.
So you agree, I think that it's critical here that the evidence was already seized. Would it matter if the evidence was, and again, we have to go well beyond your case.
I
right?
understand.
We're setting the rules for all the cases to come. Would it matter if the evidence had been seized, but the defendant didn't know the evidence was seized? And he denied the existence of it?
I think to answer that question, Your Honor, again, hearkening back to Dixon, would require a very searching inquiry to the facts of the particular situation. In McCormick, it seems, and it's an unpublished opinion, so the facts are a little scant, but it seems that the defendant in that case is at the door trying to frustrate the police from ever discovering it. So I think it just sort of depends where the person in this hypothetical is situated to determine and glean what his or her intent might be. And whether he or she in fact did know that the contraband was present is a critical component.
Let me come at it from a little different angle. The statements in this case, I had them up here, relate to what's in the defendant's mind, right?
Right.
Its intent, of course, is an element of this crime, and most crimes, maybe all crimes. But here, his statements are what he knew and what he wasn't aware. I didn't know. Is that different? The prosecution, of course, is going to have to prove intent here, and likely through circumstantial evidence, unless the defendant admits guilt of intent. But is that a way of thinking that this is different than sort of denying the existence of evidence pertinent to a different, I mean, in terms of line drawing, as Justice Zara said, we have to draw the line somewhere. Obviously, we try as hard as we can to make it consistent with the statute, but these offense variables are tricky, and we've struggled before, and more importantly, our trial courts have struggled in having to do this on a daily basis. And so the point is only that, is this evidence of what's in the defendant's mind? It's not like just sort of denying I was aware causes the police to have to do or not do anything they were otherwise going to have to do. In other words, the prosecution's still going to have to prove he was aware using other evidence. We can't go into his head, we can't download what's in his brain. So they're going to have to prove that some other way anyway. So would that be a way of thinking that this didn't necessarily interfere with the investigation?
I think so, Your Honor. I think what is in a person's mind at any time creates certainly a measure of difficulty. And I think that there has to be a requirement that there must be something specifically false and misleading that is presented by that defendant, in addition to simply maintaining his or her innocence. And I do think it's important to note here that despite Mr. Deweerd's statements, he was arrested on the spot and taken to jail. And
Is there record evidence that he was read his Miranda rights?
there is not, Your Honor. I know that that is a significant portion of the supplemental brief filed by the prosecution. There is nothing in the record that indicates one way or another whether he had been advised of his Miranda rights before making this statement. I do think it's perhaps a bit of a red herring. I think at the end of the day, it's the essence of what Mr. Deweerd said that must be scrutinized to determine whether those words demonstrated a clear intent to interfere with the administration of justice. And I think if Mr. Deweerd had not, if we knew definitively that he had not been advised of his Miranda rights, and he started talking to the police, and he told them a very elaborate tale that was clearly false, something like, I'd never been to this apartment before, I was only here to buy a couch off Facebook Marketplace, something like that. I think that could still be considered and could be scored despite the absence of Miranda warnings.
Thank you.
Subject to further questions at this time, Your Honor, I would request to reserve my remaining 3 minutes for rebuttal.
Great.
We're going to give Mr. Fitz just as hard a time.
Thank you.
Good morning, Justices.
Morning.
Again, for the record, my name is Victor Fitz. I'm the prosecutor in Cass County, Michigan. It's a pleasure to be here today to discuss this case with you. I would indicate just a quick discussion about the statute itself. Again, and as you all know, that again, if legislation is clear and unambiguous, it should stand as long as it's constitutional as well. And in this statute, MCL 777.449, which outlines what OV-19 stands for and has been the law for the last quarter of a century here in the state of Michigan, it's very simple. Did the offender attempt to interfere with, or did the defendant, in fact, interfere with the administration of justice? And again, here clearly he did, without question in this matter. I would note, maybe just going directly into some of the things that defense counsel was talking about, and maybe just one other background thing that I mentioned is administration of justice. Again, as we know, it's not just what's going in the court system, which is extremely important, but it's also the police officer's investigation, as a case law in our briefs indicate, and I think opposing counsel would also acknowledge. But in the system, there's always a very high importance in maintaining the integrity of the system. Making sure that people tell the truth, making sure that, again, evidence is legitimate, that we're not running a scam on the system, on justice, and on our citizens. Courts do this all the time. If someone comes into the courtroom and lies, clearly in that situation, the court has the option of holding the person in contempt of court if they can determine that happened, or even hoping that the prosecutor will pursue a perjury charge. And that obviously is part of the judiciary's responsibility as one of the executive or one of the branches of government. The executive branch, the prosecution, also has the opportunity to address individuals who are, again, impinging on the integrity of the system by lying and trying to get deceit and dishonesty into the system. One of those common ways is by bringing a charge of perjury if somebody testifies falsely, obstruction of justice, things of that sort as well. The legislature also has an opportunity to legitimately do that, and that's what they're doing here with this OV-19. What they're saying is, again, it's important that people they certainly have the right to remain silent. And if they exercise that right, that needs to be honored, because that's one of the cores of our Constitution and our justice system. But if someone decides to talk, they need to tell the truth. And it's not a game. It's not something where you can do, as this defendant did, lie on 4 different occasions saying, I don't use meth, although other witnesses said he had been using it just within the last 24 hours. That was a lie. He also said he was not aware of anything else taking place in that home. As he ultimately admitted in his confession, or excuse me, in his plea, that was a lie. He also said he didn't know that there was any kind of meth components or lab in the home. That also was a lie for the same reason. And finally, he tried to add some truth to his lies to make them a little bit stronger. In the 4th lie that he gave, he said, with the history of my 2 prior offenses of manufacturing drugs, if I had known they were manufacturing drugs in this house, I would have left the residence and not remained there. All 4 of those were lies, and all 4 of those were specific lies. This wasn't general, although even that distinction I don't think is of a concern here, which I'll get into in a minute too, as the court allows. But again, so the legislature has the right to say, we're going to reward you by not adding any points in OB-19 if you tell the truth. If you don't
But
have...
is that what the statute says?
I think...
I understand your point, but those aren't the words that the legislature used. They didn't say you have to tell, if you're gonna speak, and we'll get into, pre-Miranda, post-Miranda, in a little bit, but it doesn't say if you're gonna speak, you have to tell the full truth.
Well, it does say, again, that you can't hinder justice, you can't, I think words that, again, in effect, say the same thing. Again, you can, just one moment, Justice, it says you can't interfere or attempt to interfere with the administration of justice. And I think that it's a pretty common or pretty basic thing that if you're lying, you're trying to impact a just result here, because you're trying, in this case, he's trying not only to take the attention off of him so that he doesn't have to be held to his just ends for what he did. He's also, it has more of an impact than just him, too, as far as the administration of justice. When somebody says, again, takes the law enforcement down a rabbit hole and takes them off of following a red herring, it slows the process down. And I can tell you, this is not my comfort zone being in front of you. I don't do this every day. I think the last time I did this was 26 years, 1 month, and 3 days ago. And I think the only justice that there was, none of you were here, there was a name Kavanaugh, but it was a different Kavanaugh at that time. So, but I can tell you that being a trial attorney, that is my will.
Time out.
Yes.
We get to ask questions now that
Very
light
good.
is green. I'm finding some appeal in defense counsel's distinction with McCormick between evidence that's discovered and evidence that's not. How is there, given the proofs you must prove at trial, how is this defendant's statement interfering with the administration of justice? You already have the evidence that was seized from the home. You know this person was in the home. You have to prove, you're going to have to tie this person together, and you may never have the opportunity to cross-examine because they don't have to take the stand. So how is there interference with the administration of, how do these words somehow inhibit the investigation or the proofs that you have to make at trial?
I think there's at least 2 ways that happens. One is that, again, and I draw back on my experience as a narcotics prosecutor that I did for about 10 years without exception, that and homicide cases in Muskegon. Was involved in hundreds of drug cases and investigations. And I can tell you clearly, when somebody maintains their innocence or says they didn't do it, that the justice is not just for this defendant. It's for those that are surrounded too. You've also got in this case, it slows down the efforts to investigate to whether Michael Morris or Ms. Carey or those above this individual, the persons that are supplying these drugs, the other persons that are getting the drugs. It slows down the ability to get those individuals by taking the police in a wrong direction. They have to.
All right, so
Yeah,
help
where
me
was the wrong
understand how they were put in the wrong direction. How did this statement make the police think differently about others that were there and suspected of wrongful conduct?
Well, and obviously officers, they go on the evidence, they have the information they have. They have a defendant who has 3 prior charges for delivery and manufacture of drugs, 2 convictions, and they're saying, this guy is probably our guy, but now he's telling us he didn't do it. So maybe it wasn't him, maybe it was Morris, maybe it was Carey, maybe there was somebody else in this house. It slows them down, and when you're doing a narcotics investigation, time is of the essence. If you have to follow false trails, which is what the defendant was leading him on, it slows down the ability to get the other players.
And regardless of what he said, aren't they going to investigate these two other individuals because they were there?
That they are.
They're going to
but-
say, we got someone with 2 prior meth convictions who has remained silent. This has got to be our person, let the others go.
Well, again, he didn't remain silent.
I understand. I'm trying to understand how the investigation changed, how there was interference with the administration of justice. That's what's required under this OB, right?
Right, and again, case law has said, again, in our brief, and, including, I believe, Hershey and McCraw and so forth, Hershey indicates that the lying to a police officer constitutes interference with the administration of justice sufficient to warrant points on OV-19. Another case law suggests that too, including Barbary and so forth. But again, when you have to look in other directions, it takes away resources, it takes away time, and those are 2 valuable things when it comes to trying to make sure that that all parties are brought to justice in this case, both the guilty and the not guilty, as well as those persons who maybe are not immediately on the scene. I can tell you again, it's indicated, if we have someone who says that I did it, he chooses to speak and he tells us the truth and he says, I did it, I was a person, then we can immediately say to that person, do you want to cooperate? Do you want to take us to your supplier in Detroit, again, when I was in Muskegon, which we did quite often, or Chicago. But when they say, I didn't do it, then we've got to say, okay, well, we don't have this resource. We've got to go over and talk to these individuals.
But to the argument from brother counsel, they have the right to maintain their innocence. They don't have to, I mean, I'm trying to decide or determine when you say they have to be truthful, so either they have to stay silent, or if they speak, it has to be the full truth. They cannot say that they're innocent.
That they have 3, I believe, I agree with defense counsel that, opposing counsel, they have 3 options. They can confess, they can remain silent, or again, in this situation, but there is not an option of talking and maintaining your innocence. I've had many cases.
It's an option, it's just going to cost you. Should you be convicted, you're going to get extra points in the scoring.
Also, too, but that is something, for instance, maintaining your innocence, there's no constitutional right to verbally say out on the scene, I'm not guilty, I'm innocent, I didn't do this. I've had that happen many times in cases, and again, that is a piece of evidence that we actually end up ultimately using. For instance, if you have somebody that says...
So back to your point, you say, well, if they speak, they have to be truthful. If there's a blanket denial, I didn't do it, in your view, that would be enough to assess points under OB-19?
Yes, yeah, and again, too, let me go into that a little bit. I think it's a clever effort on the opposing counsel to say that that there's some more virtue in a general denial versus a specific denial. But let me take you through many times it's actually the reverse. I'll give you an example of a case I tried a number of years ago, Carolyn Richardson, an individual who, again, she was in a house, she had some money, $6,000, and there was some cocaine residue in the house. In that situation, if she would have said, I didn't do it, and that's it, she says, I'm innocent, that's a stronger defense than what she actually did, which she said, that money came from my brother, who played on a basketball team here in college in Michigan. He got that money when he was in Italy, and that's where this money came from. It wasn't drug proceeds. Well, that specific denial, those specific things that she said she did, those instances actually made her case weaker than if she would have just done a general denial. If she had just generally denied, we might have never charged her. But her specific denial allowed us to go talk to her brother and find out that that was a lie. Same thing if somebody...
So let me just
Sure.
continue down this path. If defendant said, I maintain my innocence, that for you would be enough to score under OB-19?
If it's a lie,
Well, in this case, you tell me.
And
That's what was said in the investigation at the time of the arrest. I maintain my innocence. Is that enough to score OB-19
Yes.
10 points?
Yes, because we now know it's a lie.
Okay.
That was a lie.
I maintain my constitutional right to be presumed innocent.
Again, in that situation, you've got
Now it's
two
true-
opportunities.
now it's truthful,
You've
right?
got 2 opportunities. That is not in Miranda. Miranda, you can do 2 things. You can
Well,
ask for an attorney.
I'm not talking about Miranda. Now the defendant has said something different. I maintain my constitutional right to maintain my innocence. No scoring of 10 points there, right? I mean, where's the lie?
Again, I go back to Miranda. There's 2 options, remaining silent or there's asking for an attorney. to assist you. And again, this situation, if you say I'm maintaining my constitutional right, that I didn't do this, again, that be my position, that could come,
I don't
could
think
come in.
Miranda requires you to remain silent. It's just if there's going to be questioning involved, you're entitled to know what your rights are. Are you, so you didn't answer the question. I maintain my constitutional right to be presumed innocent. Is that 10 points for speaking?
Well, I think putting the magical words, my constitutional right, I think that I have, is what I have problems with. Because again, I have defendants constantly, it's routine for them to say, I'm not guilty. They'll say that for hours, or I'm innocent. They'll say that for hours. And then in trial, again, we'll put on the video showing that, again, they committed the crime. And then we play their statement where they're saying, I'm innocent, or I didn't do it. And many times that ultimately leads to them, they say they want to continue talking, but
What are you trying to tell me here? It's highly unlikely that any defendant were to say that, but if they did, it's probably not 10 points. Is that what you're telling me here?
No,
You just
I
don't
think-
like the way it's phrased?
I think that even if you use the word, my constitutional right, again, I think that can come in.
How?
Of course.
That would be enough to score 10 points? I
They're maintaining their
my
constitutional-
constitutional right to be presumed innocent.
I guess the distinction there would be that they're saying, and they don't have a constitutional right to maintain innocence, they have a constitutional right to say they're not guilty.
To be presumed innocent until proven guilty.
If they're saying they're maintaining that constitutional right, as opposed to saying that I am innocent or I am not guilty, I think that's the distinction. Because if they say I'm innocent.
So are you telling me we score 10 points for that statement or we don't?
I would say that, I would agree with you. You've taken me down that path, and I'll agree with you on that. If they say those magical words, that I maintain my constitutional right to maintain my innocence, I think that's distinct from saying I'm innocent or I'm not guilty.
Okay, and does the rule that you're proposing, does that apply pre-Miranda, post-Miranda, doesn't matter? So law enforcement shows up at a residence, they start talking to, who they believe is a potential suspect, and they start asking them questions. They have not read Miranda rights, and that person starts answering, nope, I don't have anything to do with this.
If the statement is inadmissible for a violation of Miranda or a Walker hearing violation, then it shouldn't come in.
The law enforcement has just shown up. They've gotten a call for whatever reason, they've shown up to a property, and the potential suspect answers the door and starts having conversation with law enforcement where they start asking questions. Miranda rights have not been read. And if the potential future defendant says, I don't have anything to do with that, I don't know anything about it, that didn't happen here, whatever.
That's going to depend on whether it's a custodial situation or not. And again, but to touch on Miranda, I would note that, again, it is correct that in our brief we discussed Miranda, and opposing counsel is correct that was not mentioned in the pre-sentence report. But again, the record, police report itself, on page 14 of the 16-page police report, it says very clearly that his Miranda rights were read to him, and again, that he waived those. So again, this is not a situation where they're claiming that there was a Walker, there needs to be a Walker hearing, or there's a violation of Miranda rights or custodial interrogation.
So counsel, I mean, certainly the published Court of Appeals cases that we have on record all show OV-19 getting scored when there's something a little more proactive. They lied about a name, or they did something to evidence, or, obviously what we're struggling with is, does this basically get scored every single time a defendant says, I didn't do it, which is a pretty common reaction upon arrest?
If that's a lie, it should be scored, because again, it's something that's untruthful, it's something that hinders the investigation.
Why didn't the legislature include that language? I mean, that's very easy to write in to that OV. If you lie to law enforcement or during an investigation.
And again, there's many different ways to interfere with the administration of justice, and so certainly they can't put every word in. But our case law, both at the Court of Appeals and the Supreme Court, have said that lying to a police officer is a violation of the administration of justice. So again, I think that's pre-established law, at least from the courts. Let me go a little bit too to and I know that, and this hasn't necessarily even been raised, but I'm not sure if this is an issue of yours or not, but in regard to the Markman dissent in one of the cases where he discussed a little bit where he, and this is just to give you a little bit of perspective from the analysis of a prosecutor in this case, where he indicated in the statements that it would be extraordinary for a criminal perpetrator not to attempt to hide evidence of his crime. In other words, basically every criminal is gonna lie. Well, that has not been my experience. I haven't authorized tens of thousands of warrants over the course of my career, 40-year career. I estimated as I was going through this that about 30 to 40% of defendants do, again, in situations where they've been charged, actually do confess the crime. So I asked myself further, well, is OV-19 scored on every occasion like the suggestions have been made and so forth? So, and I know that this is not entirely scientific and so forth, a little bit anecdotal, but I pulled for the last 3 weeks in our court system, I pulled the 14 cases that were sentenced in our court system. And of those 14 cases, OV-19 was scored in about 57% of the cases, 8 of the cases, and in 6 of the cases, it was not scored. So again, it's not
Why should this matter? Why should our interpretation of this language turn on whether we believe or disbelieve that most defendants lie?
I don't think it should, but again, there's been some suggestion that it should by opposing counsel. I'd also note that again, it's and again, other research related to that same issue. There's and again, too, obviously others can do research as well, but a Springer Lake, which again is on Google, which again is describes itself as a comprehensive online collection of scientific, technological, and medical journals, books, and reference works, indicate in situations where defendants are actually guilty, how often do guilty criminals confess? And they have it broken down that on theft cases, 49% of them do confess. Drug cases such as this, 30% of them do. Assault, it's low, about the same, 32. Homicide, 3%. Sex offenses, 2.8%. On and on. And I only bring this up again, this may not be a concern of the justices here, but again, the argument that OV-19 would be scored in every situation if the people's and the current case law and the current status of the law is maintained. I want to go back just one more time to the I think the special bow that's trying to be put on the distinction between general and specific lies. And again, too, I don't think this is a case where we have just a general disclaimer. As I went through before, we've got him saying specific things. I don't use. I'm not aware of anything that was taking place here. I didn't know there was any kind of meth components or lab components here. And with the history of my 2 prior meth manufacturing charters, if I had known about this, I would have left the residence and not returned.
We have used up your time.
Pardon?
We've used up your time.
Oh, thank you.
Yeah.
I very much appreciate the time.
Thank you very much.
Thank you, Your Honors. The sentencing guidelines are meant to promote uniformity. I suspect that in most cases, OV-19, under this circumstances, OV-19 is not being scored. I think that's part of the problem, and a point that I want to make sure is made here, that this is what's done here, and I think Mr. Deweerd's conduct, which I said is not that remarkable, that would warrant aggravation, and that's the effect of this, is that because he maintained his innocence at the time of the police.
Let's talk about that for a minute. Leaving aside for the moment this issue about general disavowals of guilt, just looking at what your client said here, which is, he made a number of statements that appear to be lies, right? So the question is before us, I guess, looking at it one way, is which lies interfere with or attempt to interfere with the administration of justice. So we're sort of splitting hairs on which lies do and which lies don't. We talked earlier about whether the fact here that the evidence was already seized should matter, and you took the position that it should, that how could the lie interfere with the investigation if they already had the evidence. But I'm having difficulty, and I think this court will have difficulty trying to draw lines regarding the persuasiveness or effectiveness of lies. You know, if the lie is more persuasive, or if it's a better lie, or if it's more effective, then you score this offense variable. And if it's a stupid lie that nobody believed and it didn't prevent the police from doing anything, then you don't score this offense variable. And in particular, I think it's very difficult, and I'd like to hear your comments on how we could square that with the portion of the statute that says the offender otherwise interfered with or attempted to interfere with the administration of justice. Because the scoring seems to encompass attempts that are feckless, right?
Right.
So what is your response to all of that?
I'm innocent, I didn't know about it. Cannot score. I'm innocent, I didn't know about it. It was Morris. He's the drug dealer in town. He brought it in here 30 minutes ago. I had nothing to do with this. It's him. You can score it. I think that's the distinction, Your Honor. The latter shows a very clear intent to derail this investigation. Mr. Morris, who is the sort of third person there, wasn't arrested.
So now we're outside the realm of persuasiveness or effectiveness, and you're going with part two of my discussion we had before about whether it's his own knowledge or awareness. Those are things you, I guess if that's the case, studying your client's statement a little more closely, one of the statements he made is a statement about denying sort of an objective fact that he used meth. So one of his statements goes beyond just what he was aware of or not aware of. Would you agree with that?
Right. Well, I don't think that he said that I have never used meth before in my life.
No,
What he
I'm
said
just-
was
Yeah, I'm just reading from the PSI. Defendant denied to police that he used meth.
right, he denied guilt, Your Honor. That's what he did in that statement. He denied guilt. He maintained his innocence.
I mean, we get it.
Wow.
Your position is, it's a denial of guilt, and you don't want to engage.
And it's protected and it's sacred, a denial of guilt. And I think it's a
Justice
remarkable,
Viviano's point is that he said more than a denial of guilt.
I think paired to his essence, he did not say more than, I'm innocent.
Is there a Mir-
He
is there
didn't
a
use magic
Miranda-
words, Your Honor.
Is there a Miranda question here, somewhere in here? There's been discussion of Miranda, I don't remember.
Is there a Miranda question from my perspective?
Yeah.
No, Your Honor, I don't think so. I think the exclusionary rule prevents unmirandized statements from coming in at trial, not at sentencing. I think unmirandized statements can come in at sentencing. I think it's a bit of a red herring. The important and critical point is, what did Mr. Deweerd say? And I don't think we can expect a layperson to have these magic words that distinguish and split hairs between I'm innocent or I'm exercising my constitutional right not to implicate myself. I know I'm out of time. I did have one final point that I did hope to make that I'm thinking of now, which is that this isn't necessarily simple. This court did hold in Barbie that the plain and unambiguous, that the statute is plain and unambiguous. But this is, I think, a rather difficult inquiry. And the sentencing court in this case, in our motion for resentencing, said as much. He said that I've always struggled with OV-19 in this sense, and if somebody's pleading not guilty at arraignment, well, and then they're proven guilty, was that person trying to interfere with the administration of justice? And of course, the answer to that is it's not.
I agree with you, it's a difficult question.
Thank you. Your Honor.
Thank you both. The case will be submitted, and the court will stand at recess until 12:30.
Thank you.